My lords and my lady, we were stuck on the point as to essentially what difference does all this make, I think.
Just before we get there, and I don't actually think, the more I think about it, it's not a central point, and I don't think you presented it as a central point, but I just wanted to get my own head straight, which I think I've now done, about affordability. Is this the position? I quite understand as a general proposition private sector rents are likely to be more expensive for equivalent property than social housing.
Yes.
But what was concerning me was whether that had any real impact in the case of people in Part 7 accommodation.
Yes.
And I think what I had at the back of my mind, but I hadn't quite thought through, was the role of housing benefit.
Yes.
But is this the position that housing benefit cannot be relied on to cover the entire amount of private sector rent, and therefore, whereas there is unlikely to be a mismatch between the amount of housing benefit and social housing rent, there may well be with private sector rent. The role of suitability, presumably in assessing suitability both under the PRSO regime and generally under the Part 7 regime, does take account of rent, but it may not do so reliably in such a way as always to say it's not suitable if it's more than the amount available by way of housing benefit. Have I got that right?
Absolutely, that's a very
okay, well, thank you. I just wanted to think it through. All this is a matter of general knowledge and a bit of self-education. It isn't actually covered in the evidence, is it?
No.
But it's assumed that we would know. And
I was just trying to make a very broad point.
Yeah. That's enough said. I felt I'd give you a rather hard time about it because I hadn't thought it through, but now I have, and I wanted to make sure I got it right.
I think my learned friend's got something.
Lord, I hesitate to interrupt. There's Homelessness Suitability Accommodation Order 1992, which requires the accommodation, wherever it's provided by the local authority or in the private sector, to be affordable.
Yes,
so set out in statute.
But judgments of affordability, unless there is a rule that affordability means no more than the amount of housing benefit, which I doubt if there is, leaves an area where there could be a problem. Thank you.
Rather than explore
it. This really is deep background. It's not relevant to any of not directly relevant to any of the issues, but I just wanted to clear it up. Thank you very much.
For your clearing it up, my lord. We were stuck on the point before the adjournment about the point of Section 11, essentially. What difference does it make? I think that's the practical question that was asked. And looking again at Mr. Justice Supperstone's judgment, I think he makes it absolutely clear. If I can invite the court to turn up paragraph 78 of the judge's judgment. I just invite you to read that.
Yeah.
So what the evidence we've got between the cracks in the papers, I think it's in the supplementary bundle. But what the evidence before the judge was that children of Gypsy Irish traveller children and the Irish traveller children have a particularly low educational attainment rate. Now that may be well due to a number of factors, but one of the identified factors is because the children are always moving school, and it's well accepted and frankly a matter of common sense that children moving school is going to be detrimental to their educational attainment. It's a peculiar feature of Irish travellers, of course, that they're more likely to be moving than the general population. And so Mr. Justice Supperstone said that at the very least the authority should have considered the impact on children moving around when they're constructing their allocation policy and the 10-year rule and so forth. And so they could well have given priority to children who are in families that are transient, particularly families who are transient who come from backgrounds that have a recognised low educational attainment level. So there are all sorts of things they could have done. It's not up for us to say what they should have done. And that chimes with the facts of this case, because as we said at the outset earlier on today, the real driver behind certainly TW's case is that she wants to settle down and give her children a stable background in the way that she didn't have. She's illiterate. She doesn't want her children to be illiterate, and so we see how that plays into to this feature of the case. And so we would say it's a very important obligation. Now, I said just before we adjourned that I was going to take the court to the Nzolomeso case, which was the other judgment of the House of Lords, because which is a very important judgment. It's in the volume 1 behind tab 15. My learned friend took the court to this yesterday. You'll see from the background that this was a homelessness case, so similar territory at any rate, and this was the case, I think, that was introduced correctly as being the case where the family were moved from Westminster to Bletchley near Milton Keynes, and I think there was either 4 or 5 children. There was a number of children at any rate, and 40 miles away. And the question was whether that was suitable accommodation, and then in that found its way to the Supreme Court, and in the Supreme Court, as my little friend Mr Rutledge drew the court's attention to, Shelter Children's Legal Service intervened to make submissions with regards to section 11. We pick that up at page 560 of the report, paragraph 22 and onwards. The court's seen what's said there, will see what's said there. Paragraph 24, just to emphasise that section 11 applies to the formulation of general policies and also their application in an individual case. There's no question in this case that it bites at any rate. And then there's a section starting over the page at 562 on evidence and explaining the authority's decisions, and this was concerning the Secretary of State's intervention about explaining decisions. And my learned friend characterised this as being wholly related to the Housing Act duties. But that simply cannot be correct, because of course the Children Act informs the way in which the Housing Act duties are performed. They aren't. Children Act section 11 doesn't provide for separate functions. They merely inform the way and instruct the way in which the other functions of the local authority are carried out. And so everything that's said under the heading evidence in explaining the authority's decision is equally applicable to section 11 as it is to the 1996 Act and the decisions as to what is suitable accommodation in a particular case. And that much is clear. That much is clear from the structure of the legislation. But also, if you look at paragraph 37 at page 564 of the report, you'll see 5 lines from the bottom there that Baroness Hale said, I would also add that they, that's the local authority, cannot show that they properly discharged their obligation under section 11 of the Children Act 2004. So what that means is there was an error on the part of Westminster in that case, in that they couldn't demonstrate that they'd complied with their section 11 obligation. So all that's said there about evidencing and explaining the authority's decisions applies to section 11. And in those circumstances, the judges in the High Court in both the E case and the J and L case were absolutely correct, we say, to say that the obligation is on the authority to be able to evidence and demonstrate by reference to contemporaneous documents, etc., that their compliance with that obligation.
You say by reference to contemporaneous documents, are you limiting it to that?
No, not at all. But that's the way it's set out in the, I think it's in, certainly what was said in in J and L and E. But that doesn't matter. All we're that's perhaps nitpicking to say how we describe it. All we say is they have to evidence that they have and explain what they've done and why they've arrived at the decision that they have. Now we see there's a postscript to Baroness Hale's judgment under the heading Guidance. And here she's trying to assist authorities in the implications of her judgment. And if we pick that up at paragraph 39 on the final page of the report, 565, ideally each local authority should have, and keep, this is obviously not prescriptive, this is only guidance, ideally each local authority should have and keep up to date a policy for procuring sufficient units of temporary accommodation to meet the anticipated demand during the coming year. That policy should, of course, reflect the children's statutory obligations under both the 1996 Act and the Children Act 2004. Now that was focused particularly at the temporary accommodation policies and provisions of each authority, not just Westminster. But the principle applies equally to the housing allocations policy, as must be apparent. And so that policy must reflect the obligations under the Children Act 2004. Now the court will recall that we're concerned here with the formulation and implementation of the policy, not a particular individual decision on an allocation of a property here. We're concerned with the policy, and particularly with the 10-year policy and how it impacts on the children of Irish traveller families. And so, having said all that, we say that the judge was absolutely correct in the way he approached this case. It was a conventional application of well-settled law that we would suggest is unimpeachable. Now, what the local authorities say in response to that, they put in their written case, although not developed orally, or only developed orally in part yesterday. And if we can just turn up their written case so we can deal with the points that they make. Paragraph 71, I think it is, that it starts. Yes, you'll see 71 was first, second and third of the page. So there's just
checking something else. Where are we gone?
Sorry, I've returned to Hillingdon's skeleton argument on the appeal.
Yeah, I have it.
Although my learned friend didn't develop all these points in oral argument, I just wanted to cover all bases. It should only take a moment or two. So you'll see at 71, the first point that's made against the judge is it's difficult to reconcile the judge's conclusion in relation to residence requirements with the working household conclusion. Well, any difference in treatment doesn't make him wrong, necessarily make the judge wrong with respect to the residency provisions. And in any case, what's clear is that the judge took the view that the impact on children of the working household provision was significantly less than the 10-year provision. So he didn't think it was as important. So there may well be good reason there for that difference of opinion. But that's not, in any event, a good ground of appeal in our submission. The next point that's made at 72, the next point that he makes is the engagement of children's services. Well, the judge looked at the evidence of Miss Murphy with respect to the engagement of children's services and formed a view as to whether it was adequate. He was entitled to do so. It was in very general and non-specific terms. And there was nothing wrong. The judge's approach to that was unimpeachable. The next point that's made at 72 is referred to the detail, is a reference to what's the detailed forensic analysis. That's the PSED jurisprudence. And my learned friend said that the court shouldn't be overly forensic. Well, Mr. Justice Supperstone wasn't overly forensic because there was nothing to be forensic about, because there just simply wasn't any evidence. So we would say that that doesn't take the authority anywhere. The next point, this is the secondly of paragraph 73, is the MacDonald point. That was explored to some extent yesterday, and in exchanges we would say that the argument fell apart because of the Peretti point. Different context. Lord Simon Brown was obviously correct in the passage that's cited here with respect to Miss MacDonald. Miss MacDonald, when, if you recall from the case, was a ballerina with an incontinence problem, and there was an assessment of the needs as a disabled person, and that assessment as the needs of the disabled persons obviously encompassed disability discrimination considerations, and that's why Lord Simon Brown said that the submission that was made on behalf of Miss MacDonald there was hopeless. But it then he went on, as my Lord Justice Lewison pointed out, to refer to the Peretti case, which was the housing context where Lord Wilson said was very different. And indeed, in the Peretti case, an argument on all fours with the argument advanced here was rejected by this court. So that point there, the simple point that there's some kind of overlap between the statutory obligations that doesn't assist the local authority at all. The third point that they make, at paragraph 74, is essentially that they complied in substance if not in form with section 11.2. Well, that's easily stated but needs to be proven, and we say that there's no proof, there's no evidence that they've complied with section 11.2 in substance. Certainly haven't done so in form. So for all those reasons, the particular, as particularised in their skeleton argument and advanced in the oral submissions, we would say that there is no good ground of appeal against Mr. Justice Supperstone's conclusion on section 11. So the final point is I think the safety, another safety valves point, that and there's criticism of the authority that Mr. Justice Supperstone described other features of the cases as safety valves. Well, we say frankly nothing hangs on that. It's just the way he's describing the various features of the scheme. That doesn't take the case one way or the other. If you just bear with me one moment. No further submissions.
Mr. Wise, I wonder if I could just ask you one or two further questions.
Certainly would.
I think I'm right in saying that you accept that an ex post facto justification is a possibility.
Yes. You are right, my Lord, unequivocally.
Do you accept that it remains a possibility in this case, bearing in mind the second round of TW litigation?
Yes.
In which Hillingdon were given a chance to justify the impugned PCP.
Yes.
The reason I ask is that if you look at the order that the judge made,
Mr. Justice Supperstone's order.
yes, tab 5 of our core bundle.
Yes.
He declared that the residence qualification unlawfully discriminated.
Yes.
Now, I was comparing that with the order that was made in Cole, which you will find at tab 19 of our authorities bundle, where again it was accepted that it might be possible to justify the discriminatory measure.
You just bear with me one moment while I remind myself.
Last page of the report,
Yes.
2109, where the Supreme Court declared
Yes.
that the provision of approved premises constitutes direct discrimination, which is unlawful unless justified. No
Yes.
such justification has yet been shown.
Yes.
So I was wondering whether, if we were with you, we should alter the judge's order so that it declares that the impugned provisions constitute indirect discrimination, which would be unlawful unless justified. No such justification has yet been shown.
No difficulty with that whatsoever, my lord. That's entirely consistent with what we've submitted, that,
Yes.
that there can be an
It's
ex
just
post.
the form of the order.
Yes.
It may be rather too prescriptive in view of the fact that both you and Mr. Burton accept that it is
Yes.
potentially
Yes.
still open to Hillingdon to justify the policies.
The terms of the agreed order were, the order were actually agreed between the parties,
Yes,
by the way. But I accept your lordship's point entirely, no difficulty with that at all. Are there any other matters I can assist you with?
Thank you very much, Mr. Wise. Yes, Mr. Swales.
My lords, my lady, I think given the way in which the case is developed, I can be brief. And I say, first to say the Commission is grateful for the opportunity to intervene both in writing and
So the
oral.
court is grateful for your submissions.
It is a point of importance both in terms of housing allocation policy but also discrimination law more generally. My lords, my lady, the particular disadvantage point, this was in the Gullu case, and the error which we say Justice Mostyn made in relation to that, we're grateful to Hillingdon for the indication that they don't defend that. And I won't say any more about that, it's in our skeleton at 18 to 21, but we do say it is a point of some importance, and it's part of the reason the Commission intervened in this case, particularly about how one selects comparators in this area of law. Second matter I wanted to deal with is that my learned friend Mr. Wise this morning referred to paragraph 34 of our skeleton argument, where we had said it wouldn't help in relation to a decision that disadvantages Jewish people, for example, having interviews for a job on a Saturday, if the employer has assessed the impact on BME applicants. And my Lord Justice Lewison expressed a concern about whether that meant, well, decision makers have to assess every single potential group. And our position is they certainly don't. The issue about considering impact arises in two ways. One, it arises in relation to the public sector equality duty. And what we do say in relation to that is clearly there will be an almost infinite number of potentially affected groups. And obviously when undertaking the public sector equality duty, it is not expected that the decision maker will consider absolutely everyone. What we would say in relation to that is there is, we would say, an obligation to consider at least obviously potentially affected groups, and one that may have arisen in this case, but because the point wasn't taken by TW, would be if you have a residence requirement, is that something sufficiently obviously detrimental to Irish travellers that one would expect at the PSED stage that to be considered? But as I say, that hasn't arisen as an issue because that point wasn't taken in TW. In the Section 19 context...
Just on the Section 149 point, you get to that point simply by saying that the obligation is only to have due regard, and due regard allows you to build in these realistic assessments of who you have got to assess the impact on and who you can disregard. That's fine, I just wanted to see how it worked.
Yes.
Yeah.
That's how we accept it comes in, and that's why the obvious category, there may be a category you say this is sufficiently obvious that you don't have due regard if you don't consider them.
Can I just ask you how that fits in with Mr. Wise's argument about the Children Act? Because if you don't have to consider every little tiny niche group at the first stage, and really it's when someone cries foul or raise it as an issue that they then have to consider it, would you say then the obligation under the Children Act 2004 effectively goes hand in hand with that? that it's at the stage where you have to consider a particular identifiable group that the obligation under the Children Act 2004 kicks in.
Well, that certainly sounds right, but I'm slightly loath. I haven't got instructions from the Commission. We didn't intervene on that point. That certainly sounds correct, but I'm slightly...
Because the way Mr Wise was putting it was, he was saying, well, you know, they could have a policy that said about primary school children or whatever, that related specifically to his case effectively. But if there hadn't been an obligation to consider his lay client's particular group at the earliest stage, then presumably they couldn't be in breach of their Children Act obligations had they not specifically considered the welfare of that category of cohort of children at that stage.
Well, I wonder if I could duck that just because I don't have instructions on the Children Act. The Children Act point I've slightly... but certainly we say that on the PSED point.
Yeah.
The other area that pre-consideration comes up that I am going to make submissions on is the Section 19. In the Section 19 justification issue. And here, of course, under Section 19, there's no obligation to consider at any stage. The reason it comes up is there evidence of justification? But of course, as has already been canvassed, by the time we get to that stage, we're effectively at trial, and the court is considering whether the defendant has established justification. So at that stage, they'll of course been told about this is a group. The group will have already established potential disadvantage under Section 19(1)(c, and they will then be able to put, as we've heard, post-decision evidence in, so that the court can decide.
It's a nice point, but I think arises here whether you could say, as part of, even in theory, the whole of a justification defence, we now do realise that our policy has this disparate impact, but we couldn't reasonably be expected to foresee this, and we're going to change it now. But at the time of the act complained of, our justification is that it was an impact we couldn't reasonably have foreseen. I can't recall having come across a justification defence advanced in that way, but
I can't tell what our position would be that wouldn't work, because you still have, what you can do is you can produce evidence now.
Yes, that's a different, absolutely.
What we say, our position was, but you couldn't. You can't justify by the fact that you've never considered it, because what you have to show is that the burden falls on.
Absolutely. I mean, conventionally, one's looking at what used to be called a long time ago objective justification, and that need for objectivity is still there, though it's dropped out of the label. And so the conventional answer would be, well, it really doesn't matter what you knew at the time. Either this was a proportionate means of achieving a legitimate aim, or it wasn't, because... but one might think that in certain classes of case, that might be unjustified, someone liable to discrimination in those circumstances.
I mean, I want to think about it more. I mean, at the moment, it seems to me that simply on the language of 11(2)(d, is it a proportionate means of achieving a legitimate aim? And it's difficult to see how, and it's in a slightly different point, but in the sense it's not a subjective test in that a defendant cannot come along and say, well, we think that this has struck the correct balance. Similarly, it's not my initial thought of this, but it is also not open to say, well, we didn't think about it and there were good reasons for not thinking about it.
It's probably self-indulgent to me to raise the question, so I don't think it does arise here, no. But it's on the fringes, is the way the case might perhaps have been put, but it isn't, hasn't been put, I would say.
And I will come back, there is one point at which it does matter whether it was the issue was considered at the time, and I will come back to that. Next was the Baroness Hale, or us attempting to explain Baroness Hale in the SG case as to whether you're justifying the measure or the discriminatory effect.
Yes.
And it may help just to turn up the passages that we were dealing with. It's at volume 1, tab 13. paragraphs 188 to 189.
Sorry, which paragraph?
188 and 189. Well, but it may be helpful just to read this if you haven't already, the two paragraphs.
Sorry, it's behind, sorry.
It's 14, volume 1.
14. Yeah.
And what Baroness Hale says there, or she says 2 points arise from STEC. This is 188. The STEC being a direct discrimination case. The first is that it's not the scheme as a whole which has to be justified, but the discriminatory effect. She then makes at the end of the paragraph an observation which is about indirect discrimination. She's talking about the case itself. This is the first round of the benefits cap case. And says what has to be explained by the government is not why they brought in the benefit cap scheme, but they have to explain why they brought it in a way which has disproportionately adverse effects on women. She then goes on at 189. I assume this is the second point, the first point being 188. And she says indirect discrimination is different, and it's the between B and C in the middle of that paragraph. Measure itself which has to be justified, rather than the fact that women are disproportionately affected by it. I mean, also, this, the way we understand the position is this. In both direct and indirect discrimination cases, the proportionality exercise is a balance between the benefits of the relevant act and the impact of the resulting discrimination. And the difference between direct and indirect discrimination is what the relevant act is. But ultimately, you're still conducting a similar balance. And in direct discrimination cases, the relevant act is a difference in treatment because of a relevant, because of a protected characteristics. That's section 13 of the Equality Act. So you start with that act, which is the difference in treatment, and you say, well, is there a justification for that?
Might it depend on which protected characteristic one is dealing with? I thought it was impossible to justify direct discrimination on the ground of race.
In fact, in the domestic scheme, impossible all except for age.
Right. So what Baroness Hale says about just the difference between justifying indirect discrimination and justifying direct discrimination, which is the opening sentence of 189, may not be universally applicable, may it?
But my lord, that's right. There are rare. Firstly, she's talking about Article 14 here. This is an Article 8 and 14 case, in which case there you can justify both direct and indirect discrimination. But my lord is absolutely right. There are only very limited circumstances in which.
We've got to be a bit careful about reading this across to our case, haven't we?
We would say no, my lord, not in terms of at least of where the starting point is for discrimination, because I think that the indirect line that she has there, I think, applies across the board, which is, in a direct case, you start with the relevant act's difference in treatment, can you justify it? In an indirect case, what you start with is an apparently neutral measure, a PCP, which applies to everyone, but has a disproportionate adverse impact on those with the protected characteristics.
So it's really only actually quite a small analytical point of analytical accuracy, rather than a point about a difference in the nature of the exercise.
Well, that was the point we tried to make in our note, yes.
Yes,
so we recognise we've made an error, but we say it doesn't make a difference because ultimately you're involved in a similar balancing exercise, which is impugned measure, whether that's treating differently or a measure which treats everyone the same, and then you have to say, you weigh that against, in one case, treating one group less favourably, in another group treating the same but with a disproportionate impact. But all I accept in time, my Lord Justice Lewis's point that this is may need to be looked at in more granular detail, but at a very sort of abstract level, that's the description, I think, of the difference between direct and indirect. But as I say, we say it doesn't make a difference. It's only for the purpose of this case. Because again, what one is doing is balancing here legitimate aim of residency requirement as against the fact that it makes it disproportionately harder for Irish travellers, foreign nationals, to obtain housing. And the reason we say that's relevant to the safety valves point, whether one calls it safety valves, mitigation, or alternative ways up and in, is this, and we deal with this, I would say this has now been dealt with in detail by the other parties, but we deal with it in our skeleton at 35 to 44. And our position is that as a matter of both principle and authority, and that's the H and Ealing case that learned from Mr. Burton took you to this morning, a safety valve is only relevant if it alters the relative disadvantage, and that's because what you're balancing is, the ultimate balancing exercise is benefits of the measure against discriminatory effect. So unless you're altering the discriminatory effect, the safety valve, mitigation, etc., will not be relevant. But the next point was dealing with Hillingdon's argument that means mitigation, safety valve, etc., require direct discrimination, would therefore be unlawful. And what we entirely accept that if they did, and there wasn't one of the rare statutory defences for direct discrimination, they would indeed be unlawful. But it's quite clear that they can operate in ways that are not directly discriminatory, and the H and Ealing examples that my friend Mr. Burton took you through this morning are precisely those. They were a series of mitigating safety valves, however one puts it, which did reduce the disadvantage, but which were not directly discriminatory.
Well, there have been two suggestions in argument thus far. One from Mr. Burton, a rule for refugees who are don't share a protected characteristic,
Yeah.
And one from Mr. Wise, some sort of PCP which indirectly discriminates, but which could be justified.
Yeah. Yes, precisely. Yes, those kind of measures, and the one, for example, that Mr. Wise suggested would be one that one would say would be particularly targeted to the disadvantage or the reason that these measures disproportionately affect Irish travellers is a recognition that certain people have lifestyles, peripatetic lifestyles, or they may not have settled and now wish to settle. The reason, as my Lord said, that would be indirect discrimination is that a disproportionate number of those people would no doubt be Irish travellers, but there may be other people who also have had...
New age travellers.
Yes, for example. Secondly, on safety valves and direct discrimination is... my own friend, Mr. Rutledge, took you to paragraph 42 of our skeleton argument. And I think I leapt up at the time and was told I would be able to defend it in due course. It's and he relied on our submission at 42 of our skeleton to say, if we were correct, it would mean Hillingdon would not be able to reduce its residence requirements, he said, to 5 years, 2 years, or even 2 months, even 1 month. And we say that doesn't follow at all from what we said at paragraph 42. Of course it's permissible for Hillingdon to reduce the residency requirement. The error seems to come from the last line of our, or misreading, we say the last line of paragraph 42, which is where we're talking about safety valves. This is something slightly different. This is actually amending the PCP itself. But what we say there, and this applies equally, is that it's only if it reduces or ameliorates the disadvantage that it's relevant. We don't say there it has to remove it entirely. So, of course, there may still be a disadvantage to Irish travellers and foreign nationals if you reduce it from 10 years to 5 years and down to 2 years. But the point is, it will be almost certainly less of a disadvantage. And that's why it will be relevant. You can see that actually from the facts of this case. It looks, from a quick analysis, that of the 4 potential claimants, I think TM has lived in Hillingdon since 2011, TW and SW since 2015, and Mr Gullu since 2013. And what you would see there is if you reduced the residency requirement, none can meet 10 years, 2 could meet 5 years, all of them could meet 2 years. Now, one suspects that may well be fairly typical, or certainly you'd expect that kind of thing across the board. If you started reducing the residency requirement, more people, you reduce the disadvantage. So there's nothing to stop Hillingdon doing that. Now, of course, whether Hillingdon should do that is another matter. Because, of course, one of the consequences of reducing the number of years is you also, to some extent, dilute the advantage that Hillingdon would say accrues from having a lengthy residence requirement. It means someone living in Hillingdon 15 years is treated the same as someone who's lived there 5 years. But that's exactly the kind of thing one considers when one's at the 3rd stage of the Bank Mellat test, is would we, if we reduce the residency requirement, could we do that without undermining to a sufficient extent the aim that we're pursuing? And that ties into, if I can, the final points I want to make, which is about the consequence of not considering a matter and not putting evidence forward, because precisely the kinds of things one would expect to be considered and which evidence is required, unless it is completely obvious there is no other alternative that could have been adopted, is why, for example, 5 years would have undermined the legitimate aim sufficiently that it doesn't justify, or that it remains justified despite the impact that it has on Irish travellers, on foreign nationals. It may be, and this comes to the points being made about remedy, that if this matter was reconsidered, one would look at it and say, well, actually, 10 years is the right amount. We recognise this has a significant impact on Irish travellers and foreign nationals, but we've reached the conclusion that it's a sufficiently important aim and it will be undermined too much if we reduced it. And was maybe finally...
part of the problem about this sort of thing is that these benefits, however hard you look at them, are to some extent unmeasurable. It's a question of perceived fairness that people who have lived in the borough a long time could have an advantage over those who haven't. And you can't, however, there's really nothing to measure, is there?
Well, no, I think that's right, which brings me on to my next point, which is about the role played by deference or discretionary area of judgment in this area, because one of the things I said was a failure to consider at the time a measure was enacted, generally speaking, as we've heard, doesn't stop a justification, or certainly doesn't stop a justification being put forward. What it does prevent is reliance being placed on discretionary area of judgment. It does stop a decision maker saying, well, I'm a democratically elected body and I've decided that the disadvantages outweigh. Just for my lords, my ladies' notes, I won't turn up the cases, but where it's made clear that a failure to consider at the time removes discretionary area of judgment it's in Elias paragraph 129, which is tab 22, and
I think in Brewster, Lord Carr refers to observation of Lord Matts in the Jewish free school case to much the same effect.
Yes, That's right. It's in a series of different cases, and the reason I relied on Elias is because it's specifically a Section 19 case, but it has appeared in other contexts. And so, what Hillingdon are unable to say at this stage is, well, a democratically accountable body has thought there is a significant disadvantage to Irish travellers, and we recognise that, but we nonetheless think that 10 years, for all the reasons my lord gave, and because it is impressionistic to that extent, one could see, provided they have a sense of what the extent of the disadvantage is when they're considering it, some degree of deference.
And it's admissible, but not determinative, what other boroughs have done.
Yes.
So if this really is an outlier, that doesn't necessarily mean it's unjustifiable, but in deciding whether it is, the fact that, so we're told, no one else has done more than 5 or 6 years is a relevant consideration.
Yes.
Yes.
But one point that I'm helped to remind, of course, the advantage is to some extent impressionistic. The disadvantage is more easily measurable. So one is able to have a sense of how serious a problem this is. Would this mean that virtually no Irish travellers get access to social housing? Would it mean some lesser degree? And that's precisely the kind of thing one would expect a democratically accountable body to think, are we prepared? Is this sufficiently important for us to have a measure of that sort? Well, unless I could assist further.
Can I just ask you about the role of the court in striking that balance? And I'm thinking particularly of Mr. Justice Mostyn, who seems to have expressed his own personal view about what would or wouldn't be proportionate or undermine the aims and so on. Is that, do you want to say anything about that?
I mean, ultimately, it is a question for the courts to decide whether the measure is proportionate, but it isn't going to be the court's views on proportionality or importance. It's going to be dependent on the evidence that's put forward as to this is why it's considered important, this is why, this is the nature of the detriment.
Yeah, but it is that which is the problem area. You're quite right to make the point that at least part of the equation is measurable up to a point. Namely the detriment to the disadvantaged class. But if the benefit is of a wider social character, it's all very well to say the judge is deciding it on the evidence, but there's not likely to be much evidence that enables him to do other than express his own view, which you could say is less likely to be an educated than that of a democratically elected body.
Which may again come back to why it's the general and why.
Exactly. It comes back to the point. Well, it's a completely different game when it's been carefully considered by a body, even if they then can't measure one half of it. But when they haven't done the exercise.
And that is what we say. Why it is striking that the cases Cole, JFS, Elias, the cases where claimants succeed are all ones within that category. Well, I was ready, unless I can assist further.
Thank you very much, Mr. Squires.
Thank you, my lord. I propose to reply on both cases under these 5 subheadings. Firstly, PSED. Secondly, Section 11. Thirdly, ambit. Fourthly, justification. And fifthly, why we say the appeal should be allowed in TW but dismissed in Gullu. Before I begin with that list, can I just pick up on 1 or 2 points that were raised during the course of the hearing yesterday? The Lord Vice President asked, for the purpose of the judgment, about the versions of Part 6 and 7, Lord will see that they in fact do show on the photocopying the date of implementation. In broad terms, everything in the bundle on Part 6 stood as at 2013 when the policy was adopted, and still stands. So we have the version that's applicable both at the date of Mr. Justice Supperstone's judgment and at the latter part of 2013 when the policy was first implemented. But Part 7, of course, my Lord, was amended substantially, although not materially to our case, on the 3rd of April last year as a result of the Homelessness Reduction Act. We can, if necessary, furnish the court electronically or in hard copy with the earlier versions, but we don't think you'll need them. Can I just allow Mr. Lane to pick up on two factual points that he's taken instructions on, one in relation to Lord Justice Lewison's question and the other on the question of the application form, if that's convenient.
My Lord, my Lady, the 2 points are, first of all, the question was raised about out-of-borough placements under the policy, and that's obviously a very quick answer I hopefully can give. And there's also the question as to the form itself and what it asked in terms of the ethnicity that people wanted to declare.
Sorry, so then just something we have to get used to when we're live streaming. I think yours is the one slot where you aren't on camera. If you just move a little bit closer to Mr. Butler, if you rest your papers on his stowaway rather than yours. Yes.
And in respect of the latter points, I've been advised and I've been instructed that the forms that are used are both online and hard copy, and they do ask, and I've only copied the relevant part, questions which give a number of categories, which I can hand up to the court now.
These are forms you fill in to get onto the register?
That's right, my Lord, yes. It's the part 15 you'll see on the form.
Thank you.
And I think the question was asked, particularly looking at the 2013 Equality Impact Assessment, was that obviously the number of groups in that assessment are much less, and you can see that they have been amalgamated to an extent, given the variety of different options provided at present. So that's what people have the opportunity to answer if they wish.
So we can infer that the group white in the impact assessment is the 3 groups which are described as white British, white Irish and white other background.
That's right,
and you would expect an Irish traveller to sign one of the second 2 of those.
The refugee asylum seeker is on the form too.
I'm sorry,
Under Part
Part
60.
16.
Part 16 support needs.
As is
refugee
travelling,
asylum seeker,
Yes.
also on the form,
as is travelling community.
as is
Yes.
travelling community.
Yes, a refugee asylum seeker treated as a single category rather than refugee and asylum seeker.
yes.
Sorry, just bottoming out the point about ethnic, you presumably aren't in a position to tell us what BME includes. It's clearly not all the rest because it has one for other.
Absolutely. And I'm afraid I don't have the instructions on that as to how they actually compiled 2013.
No, okay, well,
There are obviously some which are obviously going to be in there and some which are perhaps more debatable.
it's
No.
yes, it's not. It's clearly now's not the time to go into it. It's clearly not terribly logically put together. Because one would assume that Albanian or Kosovan would also be white, but
Whether that was how they were actually did.
we won't know. Yep. Well, thank you. You've obviously taken it as far as you can.
The other point was the question of out-of-borough placements. One of the questions on the form that people are asked is where they want to live within the borough, and there's various different questions is about moving out of borough. Now, as you might imagine, the local authority, I wouldn't say has no stock outside borough, but has virtually no stock outside borough. There's a few isolated examples, but in general terms, of course, 99% of its stock is in borough. They obviously have nomination rights in respect of housing associations within their borough, but again, that's very much an in-borough matter. If somebody wants to move outside the borough, there are various reciprocal arrangements with neighbouring London authorities which can accommodate.
Yeah, they're described in the policy.
Yes.
Jonathan J, right?
Absolutely. So, in that sense, one can approach Hillingdon for Part 6 housing and can be accommodated out of borough, whether that be in housing association, assured tenancy accommodation, or local authority secure tenancy accommodation. That can happen.
And Part 7 accommodation, temporary accommodation, is out of borough, as with most local authorities?
Parts, obviously not in Hillingdon. Part 7 accommodation, of course, there is, and this is the whole Zolomiso case, there is a Section 208 requirement, of course, that it has to be in borough where reasonably practicable. But of course, it also has to be suitable, and there may be some people who it's not suitable to stay in borough, and one can think of maybe domestic violence categories, for example, where somebody doesn't want to be near where they used to live and needs to be moved outside borough, although there are equally reciprocal arrangements with other authorities where that may assist as well. But generally, with Part 7, the authority should, where reasonably practicable, accommodate in borough, and obviously they would have to justify, and since Zolomiso, they would tend to do that by reason of placement policies and procurement policies to justify why they haven't been able to do it in a particular case, while pre-assessing people who are more likely to need to live in borough than others. So it's different from the Part 6 arrangement, my lord, but which is almost exclusively in borough. There are, as you rightly say, more examples of out of borough with Part 7. So, my lord, unless I can assist you further on that matter, that's the update.
Thanks. Very good. What's my friend? PSED. This is Mr. Gullu's appeal alone. I could begin with, it's not entirely clear what relief Mr. Gullu seeks in relation to this ground. The appeal notice invites this court to make orders quashing either the scheme or the PCP, the residence provisions. But in his skeleton argument, Mr. Burton invites the court instead to make or grant declaratory relief. And I think, if it's a fair characterisation of his case, that this is very much rolled up with the discrimination point. I don't think there's an application for discrete relief in relation to the PSED, unless I've misunderstood it. I can deal with it fairly shortly. Firstly, because the Commission has set out the legal principles at 48 to 49 of its skeleton. Technical there to begin with. There's reference there to bracking and the principles that Lord Justice McComb set out in that case. Can I firstly update that? There's been a more recent decision which has bearing on this, and to which this court in the Ealing case made reference, and that's the case of Hackney and Hack, which we can find at tab 29 of the Second Authorities Bundle. And Lord Justice McComb is also a member of this court in the Hack case. Lord, this was a Section 204 appeal, second appeal to this court, and at 47 we see that the judge in that case, in the county court, had held that there was a general principle in almost all cases requiring the reviewing officer to spell out in express terms reasoning about whether an applicant does or does not have a protected characteristic, whether the PSED duty is in play, and so on. So there's an obligation on the part of the decision maker, in this case a reviewing officer, to specify and give reasons for his or her approach to the PSED. And can I just, for present purposes, invite the court to look at what Lord Justice Briggs, as he then was, says, firstly at 21, sets out principles which are very familiar to us, referring to Bracken's case. But really, I want to take the court in particular to 57 and 62. Perhaps I could invite the court to read those passages.
Sorry, which paragraphs?
57,
Yeah.
which is in Lord Justice Briggs' judgment.
And 62 in Lord
And
Justice
62
McCombs.
in Lord Justice McComb.
Very well.
And the Master of Rolls in the Ealing case refer to those passages. And
Sorry, if you want us to read it.
so sorry. Just so one has a complete summary of the judicial statements in this area.
Yep.
In terms of the application of PSD to this case, we're concerned here with the impact on non-UK nationals, and the court will have seen how Mr Justice Mostyn approached it at 44 and 45. Judgment. And the short point is, I took the Lords related to this yesterday, but the 2013 impact assessment referred to persons from abroad in a broad sense, but it referred to them. And the due regard, we say, was evident both in that document, and I don't turn them up because I'm sure we're all familiar with them now, and the subsequent officer's report, or the report to Cabinet, that there is a potential problem here. This is before the scheme, the residence provision has been implemented. We don't really know. We can see there's a potential problem. Let's keep it under check, and let's make sure that it has an element for addressing hardship if and when that arises. That was the position at that time. I don't need to repeat my case on it, because that's a cornerstone of my argument on both the PSED and on justification. They couldn't look into the future. They anticipated. They tried to assess the impact of this provision on various classes. They did their best, and their intention at the time, arguably frustrated by other events, but their intention at the time was to keep it under review. And it's a living document. We are dealing with a policy that has to change with demographic changes, legal changes, and so like. What's happening? So we say it's tolerably clear from the evidence that there was sufficient compliance with the PSED. I turn therefore to section 11. Mr. Wise accepted that this is a freestanding challenge, and when asked directly by my Lord the Vice President what difference would it have made if Hillingdon had specifically addressed its mind to its responsibilities under section 11, Mr. Wise took the court to paragraph 78 of Mr. Justice Supperstone's judgment. I'd ask the court to look at that, please. Seems to me the potential impact of the residency qualification on the education of children and Irish travellers very least required the Council, pursuant to section 11 duty, to give consideration to the need to minimise educational disruption. And then that's supported with the citation of Queen on the application of E against Islington at paragraph 114, which of course brings me to the point that I made in my opening submissions. Although Mr. Wise described my submissions as gross mischaracterisation of what Mr. Emerson had held in that case, he actually addressed the point head on. And it's quite clear, I'm not going to take time asking the court to turn up the references again. When one looks at Mr. Emerson's judgment at paragraph 114 of E in Islington, he's cross-referencing it to paras 31 to 35, Baroness Hale's speech, a judgment, forgive me, in the Zella Messo, at which stage Her Ladyship is dealing exclusively with the Housing Act scheme, not section 11, and the paragraph 37 at the end, the encapsulation of the decision says that she will add that they failed to comply with their section 11 duties. So the point here is clear. Paragraph 114 of Mr. Emerson's judgment is not on point. All those duties, those responsibilities, record keeping and so on and so forth, are products of the Housing Act scheme, not section 11, and Mr. Justice Supperstone therefore misdirected himself in applying it, and that infects not only para 76 but that paragraph 78 that we've just looked at.
It seems to me that there's a potential timeline question here. Section 11.2
Yes.
is relied upon in terms of the formulation of the policy. It's not relied on, Mr. Wise said, in relation to an individual decision. So it's relied on in support of the argument that in considering the effect of the 10-year residence requirement on Irish travellers, Hillingdon ought to have considered the additional effect on the children of Irish travellers. Underlying that submission is the implicit submission that at the stage of formulating the policy, Hillingdon ought to have considered Irish travellers.
Yes, of course.
But in looking at the discrimination argument, it's accepted that even if Hillingdon did not consider Irish travellers at the time of formulating the policy,
Yes.
nonetheless it is open to Hillingdon now
Yes.
to justify
Yes.
indirect discrimination.
Yes.
So there is to some extent a mismatch
A mismatch in those two.
between
one they had to do at the time.
discrimination argument,
Yes.
which is running together two potential
Yes.
types, before and after,
Yes.
and the children argument, which is confined to before.
Yes. Lord, I respectfully agree there is that mismatch. I wouldn't wish to mischaracterise Mr. Wise's submission, but I anticipate he would say that the two work in tandem, that whenever they visit or revisit the question of justification, they must do so through the lens of Section 11. Lord, our case on Section 11 is very simple. There was evidence put before the judge which he accepted in relation to working household of engagement between Hillingdon Housing Services and Hillingdon Children's Services as to the impact of the scheme. That's point one. Point two is my Lord Vice President's point, that this is a scheme which is designed, where applicable, to assist households with children. That's my MacDonald point. And thirdly, one only has to look at this scheme, and for reference, it's in paragraph 16 of our detailed grounds, which can be found at Core Bundle TW tab 10, para 16. Examples, we simply offer up examples of the scheme to show it's obvious that there was consideration of the welfare and safeguarding, promoting the welfare and safeguarding children. One has to be careful with the Zambrano case, what Lady Hale said in that case about there are two stages, there are two obligations, safeguarding and promoting, because that was in a case concerning, as Mr. Wise explained, persons who were shut out of the benefit system and whom it might have been said wrongly that there was a lower level of support justifiable in that case. We're in a different territory here. So our case on Section 11 is quite straightforward. There was engagement with children's services. That's evident from the scheme itself. Mr. Justice Supperstone accepted that in part. But insofar as he layered upon it additional duties, that was based upon a misdirection of law. I think the court has our submissions. I really want to give myself more time, if possible, on justification. I'll answer any questions, of course, if there's anything that the court feels I should cover, but I'll go through it, take it at a fair rate. I want to give Mr. Burton an opportunity that I promised him.
Sorry, I'm not very clear what you're saying. We've been on...
I've dealt with my first two topics,
yes,
PSVD.
exactly. Now we're coming to AMBIT.
And now to AMBIT.
Yes, and that's the one you're saying you want to take quickly.
I'll take it fairly quickly,
okay.
Not least because it may not be a surprise to this court, but I'm going to rely substantially on the Lord, the Vice President's analysis in the Ealing case.
Is there more to be said then?
Just, well, there is, but I'm going to keep it very, very short. Yes, find it. Can we go to Morris, please, which is a... Morris is at tab 45.
35.
45. Now, what's very important to note about both Morris and Barr, and both cases were on the same statutory provision. I took the court yesterday to section 185, subsection 4 of the 1996 Act, and that's the provision which says, in effect, that an ineligible child cannot give a priority need to an eligible parent. So one of the grounds for priority need is that the applicant has a dependent child. But if that child is ineligible for housing assistance, because, for example, he or she does not have a right to reside, they cannot be relied upon by the parent for a priority need. And what was said in Morris, in brief, is that that provision was incompatible with Article 8 because it drove a wedge between parent and child. Sorry? Yeah, but it was down a bit. It was Article 14 case, but it was an Article. Yeah, okay. Can we go then, please, to my submission helpful analysis, Lord Justice Sedley, on which, to which my Lord Vice President referred, in his, giving his provisional view in the Ealing case, 23 to 25. In fact, what I'm going to do, to save time if it's convenient, simply invite the Lord Lady to mark that up as relevant. But essentially, Lord Justice Sedley wouldn't even accept there that the whole of Part 7 was within ambit of Article 8. And he focused very much on the special nature of Section 185, subsection 4. That's Morris. But the case that really drives home this point, and it echoes the encapsulation that the Vice President put to Mr. Wise this morning, is the Ahmed case, which is in Volume 1. No. Volume 1, type 9. And it's paragraphs 12 to 13 of Baroness Hale's speech. And if we look at paragraph 12, secondly, the relief claim is important because no one suggests that Mr. Ahmed has a right to a home. At most, he has a right to have his application for a house properly considered in accordance with the lawful allocation policy. Part 6 gives no one the right to a house, not surprising as local authorities have no general duty to provide housing accommodation. They have a duty periodically to review housing needs. They have power to provide housing accommodation or building, also have power to nominate prospective tenants and so on.
So sorry, where are you reading from?
So in paragraph 12,
sorry.
Baroness Hale's speech.
Yeah.
And I rely in particular on the second sentence there, which I respectfully submit echoes my Lord's formulation this morning about the nature of Part 6. And then over the page, towards the end of the tramlining, the sentence just before para 14, in the case of social housing, there's not even a duty to provide it, although there is a duty to have incorporated a lawful allocation scheme. There is no legal obligation on a local authority to have any housing. There's a power, but there's no obligation. Some local authorities famously have given up all their housing stock. They have to, by laws, we've seen, have a housing allocation policy, and of course they must operate that lawfully. There is, so we say, with great respect, when the Master of the Rolls in the Ealing case referred to a right, was referring to it in the Part 6 context, and although that was based on Justice Godstead in the HA case, with respect, it was wrong. We respectfully say and invite this court to endorse the provisional views by the Vice President, Lord Justice Davis. And I turn therefore to...
Well, just a minute. Is that with one card, one bound you are free? I mean, Lady Hale says, does she not, that Mr. Ahmed had a right to be considered. Yes, he has a right to have his application for a house properly considered in accordance with the lawful allocation policy.
Yeah.
So, Mr. Burton would say, I suppose, that right, in other words, the right to have his application for a house considered,
Yes.
is a right which must be, must not be discriminatory in terms of Article 8/14.
It's got to be within the ambit of Article 8, though. It's got to be linked somehow, a non-tenuous way, to Article 8.
So your point here is the right to have an application considered is too tenuous a link with Article 8.
Absolutely, yes.
But is that only because it's an application to have a right to consider rather than a right as such? Or is it also because the starting point is that the person will already have been given accommodation under Part 7?
Well, not
or at any rate will have the right to accommodation under Part 7 if required?
Not everybody, obviously, who gets...
No, my second formulation is more accurate.
Yes. Essentially, there's no right beyond the right that Baroness Hale has referred. And I took the point yesterday to the Lynn Barnett case, Lord Justice Dyson as he was, about the meaning of a reasonable preference. It's possible to have a reasonable preference and never be allocated. So those are our submissions on ambit. Can I move then to justification? And we've been assisted on this by the Commission's supplementary note. If I can invite the Court to turn that up, please. And this was put in to clarify correct the error in the submissions as to what it is that has to be justified. And we're looking at paragraph 3 over the page. And what the Commission say is that in indirect discrimination cases, the potential discriminatory impact of a measure is considered in determining justification, but it's considered at a different stage of the analysis. That's clear from Ealing. In indirect discrimination cases, once a court has identified the benefits of the impugned measure, it weighs the benefits against the measure's discriminatory effects to determine if the measure is justified. So one's looking at two things, benefits and discriminatory effects. And we respectfully say that that's an accurate summary of the legal position. How that translates into a housing allocation scheme case, we respectfully say we can do no better than to offer up the judgment of Mr. Justice Garnham in the XC and Southwark case, which is at tab 37. But before I go to it, perhaps it might be take up the second authorities bundle. Can we just, as we're in the same bundle, can we please just go back to Ealing at tab 30 to the judgment of Lord Justice Davis at para 129. Para 129 of the Ealing case, Lord Justice Davis says, I would refer to the decision of Mr Justice Gullu in XC, itself a case relating to the validity of a housing allocation scheme. Seems to be the approach adopted in that decision was the right approach, and one which corresponds with the approach to be adopted in the present case. So this is a judgment, first instance, that's received some approval from this court. And this is one of the cases that we rely on for safety valve, but this, in short, was an attack on a so-called priority star award scheme within Southwark's allocation policy, which was awarded to working households or those who've made a community contribution. And it was a challenge by a claimant who was disabled and a carer, and who contended that it discriminated indirectly against disabled persons and women. And Mr Justice Garland found there was discrimination, but held that it was justified. And can we please pick it up at 86 of the judgment? And again, it may be convenient if I invite the court either to read it to itself, or if there's not time, simply to mark up, because we say this is a model of the way that a case of this type should be approached or analysed in terms of
86 to the end, is it?
86 pretty much to the end, because we rely, obviously we rely on 100 because that's one of the safety valves. But can I in particular go to 92, determining those matters in the context of housing allocation scheme is especially difficult. Every tweak of the scheme to benefit one individual or one class of applicant is likely to have an adverse effect on another. Every exception to the operation of a preference may damage the achievement of the objective. The court inevitably concentrates on the circumstances of the claimant in front of it, and it's easy to recognise the disadvantage that a claimant may suffer. The local authority has to consider the position of all the applicants, and the court can only give the most attenuated understanding of their position. And then, perhaps not surprisingly, and this is really where it fits in, there's reference to Ahmad. And Ahmad is particularly important on this question of looking at the least intrusive means. It's very tempting in cases of this type. At first instance, Mr. Justice Waxman, as he was, did it in the Ealing case, of saying, oh, well, you could do this, or you could do that. But this is where deference is particularly important, because, not least, the reason that the judge gives at 92, everything in a housing allocation scheme is connected to everything else. And we'll see that in a moment when we look at the practical difficulties faced by a local authority when they start adjusting periods of residence provisions. So we say, respectfully, that that's a very helpful way to analyse the problem in this type of case. And we would respectfully invite the court to adopt that. Can I go back looking at the Commission's supplementary, I don't need to take it out, but this balance between benefits and discriminatory effects. So just to make it quite clear what Hillingdon's case is on this, what are the benefits of this 10-year residency provision? The legitimate aim, as we've seen, is to reward residents for their long-term attachment to the borough, which clearly has the ultimate goal of a more stable community. But as was alluded to earlier today, there's also a benefit to those who are on the scheme. It's a defensive provision for those on the scheme, because there's a direct, we say, correlation between the number of years and the amount of competition that you have once you're on the scheme. The 2013 impact assessment makes that very obvious point. If you reduce the number of years, you're going to increase the number of people coming into the scheme. So I can't do the maths on my feet, but whereas we currently got a 1 in 4 chance, it might dilute to a 1 in 6, 7 or 8 chance. And part of the balancing exercise here, which we say is a perfectly legitimate exercise for a court, given that ultimately it's a question of objective justification, is it proportionate for the benefit of a handful of applicants to reduce the residence period from, say, 10 to 5 years, when we know that that will be to the detriment of the majority on the scheme? In fact, one could anticipate a powerful disproportionality argument to the contrary.
Of course, I see the points you're making. They'd be a lot easier to grasp if, not necessarily at the time, but in the evidence before the court, that sort of exercise had been gone through. For example, one could do the arithmetic and say, reducing the period to 5 years or 2 years, say, would increase the number of people competing for the same amount of stock in each year from X to Y. I don't think that exercise has been done, has it?
Well, it has, because in 2013,
You had that graph.
the graph, it's 7A.
Yes, I see.
And this is part, I'll come on in a moment to how we presented our case to Mr. Justice Supperstone. You don't actually need any more, it's obvious.
Yes, I mean, the curious thing about the graph and the officer's comments is that they say we provided data on these different lengths of period of residence qualification for the Cabinet to consider. There's no record of the Cabinet ever having considered alternatives. There's just that one paragraph in this Murphy statement saying, well, they approved it.
I accept that. I accept all those sort of points, Lord, in this case. But ultimately, we're here on my case of my appeal on TW. I'm inviting the court. I'm saying that the judge didn't do the exercise that he ought to have done. Therefore, this court should do it in his place. That's what I say on TW. On Gullu, I say the judge did. But if this court holds, because of what is accepted misdirection on discrimination, that it should take it upon itself to do the balancing exercise there, and I don't hear an application to remit that case for that exercise, and it would be disproportionate to do so, then this court should grasp with it. It has the material.
It's difficult, isn't it? Because, all right, you've got the graph, and it says that if the residence requirement is 7 years, and the number of people will be such and such, and if it's 5 years, it will be such and such, and we've got, I think, about four or five different alternatives.
Yeah.
I mean, if in principle we're willing to do that, you say we should just pick a number, do you? I mean, how are we?
No, you can't.
That falls right into the RMAT trap. Of rewriting the policy. How do we do that?
I'm so sorry, I'm not doing that at all. I'm not inviting this court to pluck a figure from the air and say to Hillingdon, no, I'm inviting this court to say, with what Mr. Justice Garnham said and the references to Ahmed there, that this court can be satisfied that Hillingdon has made a lawful decision. There's no right decision. You can't say that 10 years is... Yeah, that he's made a lawful decision. We, the court, have scrutinised the material available to Hillingdon. We're in as good a position, objectively, to see whether this is justified. But this is linked, of course, to my safety valve argument. And we're satisfied, although we have our Brewster direction firmly in mind on one hand, because this is post hoc ratification, But on the other hand, we do bear in mind that this is a publicly, democratically elected and accountable body that's done this, that ought to know a bit about housing and housing needs. And we can be satisfied as a court on the information that's been provided to us that a balance has been struck. And it's a balance that is within the four corners, as it were, of their discretion. That's the way I put it. And that's the way, with respect, that was the way we put it to Mr. Justice Supperstone. We didn't just rely on historic documents. Mr. Justice Supperstone, during the course of the hearing, asked me, well, what do you rely on historically? And I told him. But as we can see from the judgment, our case was very much, that's what they did then, but look at the policy. We offered up the scheme, and we said, look at this and see. Now, can I, with those thoughts in mind, can I then go to the other side of the balance and look at the discriminatory effects? Because it's very important that we understand, in my respectful submission, how much impact these residence provisions have on these claimants. And can I just put it in this very simple building block way? One, every person who is eligible and has a reasonable preference is admitted to the scheme. Secondly, once on the scheme, they're admitted to either Band B or A, depending on their housing needs, if they have 10 years, or Bands D and C, depending on whether they're statutorily homeless, if they do not. So for the purposes of section...
Statutory homeless without 10 years got into Band D.
If they're statutory homeless without 10 years, they Band D.
Yeah.
Yeah.
If they have the 10 years, they could be C or they could be B, I think.
Yes, I'll address my lord on that point if it troubles him. Those are bandings are for strategic reasons. The reason they put statutory homeless with 10 years in Band A, if one looks at the scheme, I'll turn it up if necessary, I'm concerned about the time, is because that's where the landlord has withdrawn the accommodation and the local authority will be in breach of its statutory duty. The Band B is where the applicant is in bed and breakfast, and there are regulations which limit the use of B&B for households. So those are emerging strategic. They have to be there to protect the local authority. So that's the rationale there. But my point is that once they're on the scheme, everybody gets through the gate, and you go left into Band B and A if you've got 10 years, or right into C and D if you haven't. But you're all on the scheme. So for the purpose of section 19, the extent of the disadvantage suffered by those with a protected characteristic, to use Mr. Squire's phrase, is limited to one of banding. Bands D or C rather than bands B or A. There is no other provision in the scheme which is denied to those on the register. Now, with that in mind, can I please just invite the court to turn to tab 1 of the authorities bundle, the Act, and look at section 166, capital A5. capital A5, which is at page 11. And the subsection I want to remind the court of is subsection 5, which is at page 12. I took the court to this yesterday. That says the scheme may contain provision for determining priorities and allocating housing accommodation to people who have reasonable preference, and the factors the scheme may allow to be taken into account include, little c, any local connections. So, what Hillingdon is doing here is on all fours with its Housing Act powers. Now, that doesn't necessarily mean it's proportionate. You can have a policy always to bring proceedings for an outright possession order where the arrears exceed £5. That would be lawful, it wouldn't necessarily be proportionate. But it's the first stage. the discrimination complained of here is actually Hillingdon exercising its lawful powers. I might be in some difficulty if it stopped there, but it doesn't stop there. Because, as we've explained, if you're in Band D or C, you can get an uplift, or you can go straight to go. The way you can get an uplift, and Miss Murphy's given this in her statement, is by making a case to hardship panel. And with respect, this case cannot be decided on anecdotal evidence as to whether how many people have passed through hardship or have not. This is a challenge to the scheme, and it must stand or fall on what the scheme says. Alternatively, there are a range of reasons. One of them is where you've been in temporary Part 7 accommodation for more than the average time, where you can get a direct offer. You go over the heads of even those in Band A. And Mr. Wise says, oh, well, that contains no general discretion. It would probably be irrational if it did, because this scheme has to have a degree of transparency. So what Hillingdon has done in Section 6 is to set out very carefully crafted, what we say, wide-reaching provisions to enable it, under its Housing Act powers, to give somebody accommodation outside the choice-based letting scheme. So just going back to what are the disbenefits, we've got Hillingdon operating a scheme within its Housing Act powers. We've got Hillingdon putting into that scheme measures which enable movement within the scheme itself. The only thing that can be said, and has been said, ultimately against us, well, it's still not good enough, because if I'm discriminated against and I don't have 10 years, I have to have even more need to get into, say, Band B than somebody who comes in at Band C level and gets the automatic uplift. That's ultimately what it says, what's said against us. And that's based on what could conceivably be the most important issue in this case. Is what does it take to ameliorate the discrimination that arises in those circumstances?
Sorry to backtrack a little, Mr. Rutledge. I was a bit confused by saying that you haven't done 10 years and you get into Band C. I was just looking again at policy, section 12.1, in the supplementary, joint supplementary bundle of page 192, 191 and 192. Towards the bottom of 191, it says that the council be unable to prevent homelessness and the main duties being accepted, you go into A, B or C. And then over the page it says applicants with less than 10 years go to Band D. So I thought you said a few minutes ago that even if you didn't have the 10 years, you could go in straight into Band C.
Yes.
How do you get into Band C?
Having a reasonable preference, but not being statutorily homeless. The 2000.
Oh, I see. So
I'm so sorry. The 2016 amendment, Proposal 1, was consistent with the Jakimovic case. Was you had to put everybody who has a 166A3 reasonable preference on your scheme.
Right.
And that's what they did.
Right. So
But what they decided was that if your reasonable preference is because you are statutorily homeless and have all the additional benefits of that, you go into Band D.
right.
So that's why I've said that turning left in the gate goes to A and B. I think the Lord's with me. If you have 10 years and your priority rating is Band C, you get the automatic uplift because of the additional preference from C to B. So you shouldn't be in band C if you've got 10 years, because you're always going to be at least band B. Because you get, once you're in, you get the additional uplift.
I thought I understood all this, but I really think I don't. Does it follow from what you just said that although theoretically, when you turn left, right, which is you go into C and D, actually once you're in C you go straight through into B?
Once you're in C, yes. Yeah, that's the effect. Oh, if you go left, so sorry. Yeah. Yeah, that's what I'm saying. Yeah,
Can we just go back? Can we just go back to 166A subsection 3?
yes, of course. So I'll answer my lord, the Vice President point in a moment.
Reasonable preference must be given to 5 groups of people.
Yes.
And you say that the amended allocation policy allows anybody within these 5 groups to come into this, to go onto the scheme.
Yeah.
The first group of people are homeless.
Yes.
They go into band D if they haven't got the 10 years.
Yes. If they haven't got the 10 years.
People owed a duty under section 190, 193 or 195, they're presumably also part 7 people.
Yeah.
They go into band D if they haven't got 10 years?
Yes.
Yeah. People occupying insanitary or overcrowded housing, they go into C.
C.
Right. People who need to move on medical or welfare grounds, C. And people who need to move to a particular locality in the district also go into C. Right.
Yeah.
Can you just show me the bits of the policy which say that?
Well, I'm not sure I can, because it's the... 176. Yes. It's 2.2.4, that's the residency provision, which is at 175.
Yes.
Sorry, just let me get to 176.
Yeah, and that in the 1, 2, 3, 4, 5, 6 bullet, statutory homeless persons and other persons who fall within the statutory reasonable preference groups.
Yeah.
So that's what they did to comply with the change in the law, the clarification of the
Then
law.
we've got to go to paragraph 12, see what happens to them. Reasonable preference.
Yeah, well, paragraph 12 doesn't deal specifically with the reasonable preference categories other than homeless, statutory homeless.
Well, it does actually, because 12.2 is unsanitary.
I'm sorry, I was looking at 12.1.
Subsection 3C.
Yes.
In fact, I haven't, because I think you took us to this. I think if we go through this, it tracks, doesn't it? 166A3.
Oh, I see, and then we do get to A, B or C.
Yeah.
Yeah.
Yes, exactly. Yeah.
All right, well, thank you very much.
I think we'll save time now, but I think it might be clear if one looks at the table at the back. It's tolerably clear what they do. But in any event, that's the scheme.
Yeah.
So. So if you have 10 years, you will end up B or A. If you don't have 10 years, you'll be D or C, and the scheme facilitates that. That's the submission. And that's we say that is the deficit. That's the nature, the level of the discriminatory effect of the PCP. That you're in a lower band, but you have the ability to go up.
Yeah, I thought that was where the whole case, that is what is complained of.
Well, it comes back to, it ultimately comes down to safety valve, because however one looks at that, it's not an accurate term, but it's one that developed in the case law. We simply adopt it for simplicity. We say, yes, there's bound to be, this is Mr. Justice Garner's point, any scheme that prioritises according to various criteria is going to have the capacity at least to discriminate. It's inevitable. On one level, not suggesting legally.
On protected grounds.
Yes. Well, yes, but
Yes,
the very nature of social housing allocation, reasonable preference groups are a form of discrimination.
Yes.
It's not unlawful. So you're all the time concerned with trading off one benefit against another disbenefit, and so on. And this is why we say, in terms of justification, look at the whole scheme. Look to see what the actual disbenefits are, and it's a banding disbenefit, of a scheme that facilitates movement. Yes, I accept, I've always accepted, made it very clear yesterday, you don't get up a higher band simply because you're an Irish traveller. You can't do that, and it would be irrational to do that, because this is a housing allocation scheme. The only criterion that they can work to ultimately is housing need. And there have been a number of suggestions in this case about things that they could do. Mr. Burton said, oh, well, they could have build in a support network or medical services even. Well, local housing authorities have no legal power to provide medical services. But we mustn't lose sight of the fact...
I don't think that was what he was suggesting. I think he was suggesting that you might be able to establish a local connection in some other way, for instance, if you were accessing the support network.
Yeah, yeah, I accept that. The difficulty with that, I understand why he said that, but this is, it's so tempting in a case like this to say, oh, they could do this or they could do that or whatever. But we are at this stage of the analysis at the least intrusive means, and the area or the deference that must be paid to the local authorities scheme. And we offer it up to the court and say, well, look, it's not perfect. We're not going as far as say it's rough and ready as Lord Newberger in the Ahmed case described Newham's scheme, because it's quite clear an awful lot of work and time has gone into fashioning this scheme. It's a scheme that has gone out to consultation twice in the last 6 years. On the residence provision, there was an overwhelming support for what Hillingdon are doing, and Hillingdon has done its best to try to anticipate the effects. It hasn't picked up everyone. Lord Justice Lewison's point again was only forests national is a good one in point. You can't pick up everybody, but it's anticipated that there are likely to be problems, and it's built in protections. We say, we invite the court here to take an approach similar to this court took in the Ealing case. In the Ealing case, there was no great inquiry about what Ealing had done in the beginning or anything like that. The master of the rolls grappled with it. What does this scheme say? What are the provisions in this scheme? And we respectfully say this court should do it here. This court is well placed, probably a lot better placed, to do that exercise. And we say...
And in doing so, we can't take into account the 2018 exercise, so we know nothing about the impact on the Irish travellers.
Is that the officer's review?
Yeah.
No, I thought I'd made it quite clear.
I know, but I'm sorry, I know you have, but I'm just trying to see what material we have to do this exercise on. We don't have any material about the impact on the Irish travellers, or indeed on the refugees or non-British nationals.
Yeah, you don't need it. That's my submission. The court does have that material, because they are all necessarily picked up in the way that the impact assessments approached it. They're not specified, they're not singled out, but they are included. And this is our submission on that. So you do in fact have the information before you from impact assessments. I agree, it's speculation as to whether an Irish traveller would choose to describe themselves as white Irish, or other, or unknown, or I don't want to give the information. I accept that. And this is one of the problems with respect of evaluations in the Equality Act
or travelling
sphere.
community, which is one of the boxes they could tick.
Well, yes. Yeah. Well, Lord, yes. But, but what they did with the information, they looked at, what was the cohort they looked at? The cohort was all those, and there were many, many more at the time, on the housing register. And they told themselves, and they know, that that reflected the demography of the area. So it was a pretty good snapshot that they had, and they assessed the impact of the residence criteria that they were contemplating introducing on that cohort. So what does, to answer the Lord's question directly, what does this court have? It has the work that Hillingdon did in 2013, again to a limited extent because it was a more focused consideration in 2016, but it has all the work that Hillingdon did in 2013, but more importantly, it has the scheme. And when it looks at the scheme, it will see that what Hillingdon has done is to attempt to create a balance. I say a fair balance. Mr. Wise would say, no, that's not good enough. It's got to be something that addresses the discrimination. But I've made my submissions as to the level of the discrimination here. And we say that it's tolerably clear that this scheme does meet that. I don't think that if I were to develop further my submissions on safety valve, it will assist the court, because I think the court knows where we are on that, and has in particular the submission about the negative effects of bringing the period down. That's the problem. So that's our case. Where did Mr. Justice Supperstone go wrong? On any reasonable reading of that judgment, we didn't get past stage one. It cannot be construed as a judgment where the court has grappled with the issue itself. In any event, if we're right on safety valve, then that was a material misdirection, and that through Lord Carnworth's direction gives this court not only the ability, but we would respectfully say the responsibility of asking itself the question of whether this is a proportionate means of achieving a legitimate aim. And we say discreetly that Mr. Justice Supperstone misdirected himself on Section 11 for the reasons I've already given. And as for Mr. Justice Mostyn, although he expressed himself in very brief terms, they were quite clear, and in our respectful submission, on the evidence that was presented to him. And remember there, what the court was focusing on was non-UK nationals, a much wider group. And as Mr. Justice Mostyn held, they were looked at. Once they were looked at, and it's clear, the evidence shows, not only were they looked at, but that caused Hillingdon to alert itself, A, to the possibility of discrimination, B, to the need to keep it under consideration, and C, to the need to have some form of ameliorating it through hardship. In that case, in particular, it's very clear that even if there was an obligation at the outset to grapple with it, they did. And going beyond that would, in my respectful submission, be an unlawful incursion or impermissible incursion into the responsibility of the local authority. Then we are in the manifestly territory there, we say. So short they may have been, but correct nonetheless were the findings of Mr. Justice Mostyn. So in those circumstances, Lords, this is a very important case for my clients, and I dare say for other local housing authorities. We say that this is a case where Mr. Justice Mostyn was correct in his outcome, except in relation to direct discrimination. Discrimination. We've made that concession, but that ultimately doesn't change the outcome because, as a matter of construction, under Section 19, if there's justification, there's no discrimination. I'm corrected by my law. No unlawful discrimination. But equally, we say that Mr. Justice Supperstone fell into the error. Can I? I'm sorry. Can I turn round for a bit? Those are my submissions.
Thank you very much indeed, Mr. Rutledge.
My Lords, my Lady, I hope to be very quick. 10 minutes, if I may. The first point is that there was an exchange earlier between myself and the bench about correspondence following on from Miss Murphy's statement, where a number of refugees have been referred to, and I did.
So you asked for further information.
We did, and I just have to hand that correspondence to
Were these before the judge?
It was before the judge, yes. And I have handed it, sorry, I gave it to Andy because he was busy.
Oh, I see. It's not the one you had me earlier.
No.
Oh, I see. So sorry. Didn't mean to. I thought it was something else.
That's great.
Thank you very much.
My Lords, my Lady, can I just be very brief on ambit?
Yeah.
The principal issue for determination of the court on the ambit question is it really credible to suggest that the provision of social housing, which as we've been discussing is both stable, affordable, very importantly of choice and likely to be within the locality that somebody wishes to live in, such that it isn't going to have an improved opportunity for family life and private life? If the answer to that is yes, it obviously will, in comparison with Part 7 accommodation, which, as we know, is accommodation which nobody has any particular right to, has no security of tenure, and they can be moved at any time, then in my submission it's plain that allocations of social housing fall within the ambit. And it doesn't matter that it's not just the difference of treatment which prevents you from actually getting your hands on a unit of social housing, because that's the same in any benefit system. There are always other requirements which one must meet in order to obtain the benefit. The critical question is whether or not the benefit itself has more than a tenuous connection with the rights that Article 8 protects. And in my submission, that's obvious in relation to social housing. But again, I repeat my fallback position, which is that a measure designed to ensure one remains resident in a particular area for this sort of length of time is bound to have a foreseeable impact on family life arrangements and indeed private life arrangements. My Lord, and my Lady, then, if I can move on to the question of justification. Of course it's right that Hillingdon's actions are, besides the question of discrimination, lawful. They're within their statutory powers. That's not the nature of the challenge. And of course they were entitled to form a view as to what residence requirement, if any, they should have. Second, my learned friend has done a very good job of explaining why the scheme is a rational one from the perspective of Hillingdon. And again, that's not the challenge before the court, it's not a rationality challenge. So whilst I accept the comments made in Ahmed are in fact true, that if one changes a rule over here, it may have impact on a rule over in another place of the scheme, that's not really what this court is being asked to do. The question really is whether or not this local authority, when it formulated its rules, did it in such a way that it can demonstrate that the difference of treatment that it gives rise to is justified. And it's more simple in that way, rather than requiring this court to tinker with the rules in the manner that was in fact being asked of the court in the Ahmed case. It's very drastically different factual circumstances. The only point that was made by my learned friend that was sort of, as it were, new about the justification for the rule is the reference to the consultation exercises. There were two of those, one in 2013 and one in 2016. And of course, it's a good thing that Hillingdon did those consultation exercises, not least because, of course, the 10-year rule is a contentious one. There can be no doubt about that. The difficulty is the manner in which my learned friend, with respect to him, reflected what was said about that, because if one looks at the supplementary bundle, this is the joint supplementary bundle, tab 3, page 47, we can see where the figure of a 77% approval rating for the rule comes from. Tab 3, joint
So page
supplementary.
which? 47?
47. In the joint supplementary bundle, behind tab 3.
Right, okay. Supplementary bundle.
Which page? Sorry.
Page 47.
Yeah.
It's actually a paragraph number, I believe, 52, beginning with the words letters 77%. And what I'd invite the court to do is just then read the comments underneath it.
But hang on, what's the value of these anyway? 77% of respondents, but the respondents are just a mixture of individuals and bodies.
Well, I'm not relying on this to support my case.
No, I understand that. Perhaps there's a point I should have put to Mr. Rutledge, but he made it very much in passing.
To fair to Mr. Rutledge, Mr. Justice Mostyn, in his judgment, does sort of allude to this being a locally made decision democratically.
Yeah,
and that might indeed be the... Yes. The only reason I'm taking the court to this passage is this is the 2013 consultation document where it said 77% supported it. And they plainly supported a residence requirement, which, if one looks at the typical comments, they're all ones which would suggest that the 10 years was perhaps too long. Or indeed, there should be exceptions to it. It's a simple point in order to avoid the impression being formed that there is this large body of people who are absolutely committed to the 10-year rule. Then just moving then to the more specific question about stage 3 of the analysis and alternatives. Mr. Rutledge explained in detail why there would be a difference in impact if one moved, for example, from a 10-year rule to a 5-year rule, and has the advantage of being able to look at some evidence, at least in 2013, about what the impact of that might be, and obviously made the point that if you narrow it, more people come onto the scheme, and therefore one's entitlement to the ultimate benefit, social housing, is to some extent watered down, and of course I accept that. But the flip side of that, just so we're absolutely clear, of course, is that if you have a 10-year rule, then you're starting to allow residency to dominate over need, because many more people would have an acute housing need, which is not being met because they can't meet the residency requirement. So that's the sort of balancing exercise that my learned friend Mr. Squires was alluding to as being the principal responsibility of the local authority, and a difficult one, certainly for this court, to make without the benefit of evidence. However, if I can just make this simple point, which is none of that really goes to the other alternative remedy that might be available to Hillingdon should it be required to reconsider this issue, which is whether or not a discrete exception or modified rule should be made for certain particular groups because of their particular circumstances. Of course, the two groups that we've been looking at in the course of these appeals are such groups. A particular rule which would reflect the fact that nomadic people don't necessarily stay rooted in a particular area, and that refugees don't have choice about where they might ultimately live, could be equally fair, affect a small group of people, and not undermine the principal purpose of the rule, which is to largely give social housing to people who can establish a connection through 10 years residence. And just on that point, if I can just highlight what the guidance says about the statutory purpose, at least, for having residence requirements, which is in tab 55, paragraph 12, which is page 5, behind tab 55.
Sorry, I was just checking something. Where are we going now?
We're in the authorities bundle, tab 55, statutory guidance, paragraph 12, about residency requirements. And the relevant sentence is the first one about purpose being, or at least from the government's perspective, local authority authorities should ensure that they prioritise applicants who can demonstrate a close association with their local area. So the real point here is this, would it be open to Hillingdon to devise an alternative rule for these particular groups that stayed faithful to that requirement of demonstrating close association, but didn't require the impossible? And in relation to that possibility, we have still not only heard or been directed to any evidence about why that would be unacceptable having regard to the full purpose of the rule. With the greatest respect to Mr. Rutledge has neither explained it either. Sorry, Mr. Rutledge has not explained it either. He hasn't advanced a reason which explains why such an exception would do such damage to the objective that the residency rules are designed to promote. And just finally on that question of evidence, in the course of his submissions on the PSED, Mr. Rutledge made the point that obviously they tried their best in 2013 and 2016, and of course that may well be, and no doubt is correct. But he also said that they would keep it under check. And what we've now seen in this document that's been produced, at least insofar as it was available in 2016, is that it would be perfectly possible for the local authority to assimilate the evidence about both travellers and refugees in order to consider whether or not an alternative.
Sorry, you're referring to the 2018 Officers' Review, are you?
No, I'm now
So what are
referring
you
to
referring to?
2016 Qualities Impact Assessment.
When the policy was changed to allow the reasonable preference groups to join the register.
Yes.
Now, that was after your challenge.
Yes.
Was it after the TW challenge as well?
No. The challenge brought on behalf of Mr. Gullu originally said breach of statutory duty on the basis that because the 10-year rule applied across the board and kept out lots of people who otherwise had a reasonable preference, it was in breach of section 166.
Right, so you were taking the point that the Court of Appeal ultimately decided in the case whose name I can't pronounce.
Checker, yeah, I can't pronounce either. They're all getting around it. Exactly that. So it then modified the scheme to take account of that, and of course that ground fell away. So we were then focused on discrimination only. But my broader point here is there really wasn't anything stopping the local authority, particularly now that we can see what questions were available to people signing onto the scheme thereafter. Excuse me one moment. I wasn't intending to say anything more about any of those points unless I can assist further.
But you'll only have to if we ask you to. No? Well, we're very grateful to Council for having been so flexible and in the end, as it turns out, realistic, although at 1 or 2 points it looked as though it might not be the case, about their time estimates, and grateful for their submissions generally and for the work of those behind them. We will, of course, be reserving our judgments. That means that in due course, draft judgments will be circulated to Council for correction of typographical and other minor factual errors, and so that the parties can hopefully agree supplemental relief or supplemental orders, or if they can't, file short written submissions, which we will, on the basis of which we can decide any supplemental issues. There will then be a handout which the parties need not attend. Thank you all very much.